Hi, everybody. Welcome to Class 2 of Fundamentals of Legal Research. We're going to be actually doing a lot today, talking about the role of the researcher in our U.S. legal system. Now, hopefully, some of this is review and you've gone over it in Intro to Paralegal Studies. I know if you're taking today's law office, you go over it again, but I think it can never hurt to go over our system, our U.S. legal system, and our sources of laws. Okay, so why are we performing legal research? Isn't the law the law? And once you learn it, you're good. The trick is that no one really knows the answer to every legal question. Um, Even if you're practicing law for, 10, 20 years, each legal question is unique and you might not know the specific answer to every legal question. Plus, the laws are always changing, right? You have new lawmakers taking oaths of office and new laws are introduced and you have new case opinions being filed every day. And, maybe you have a case, an issue that is in one area or jurisdiction. Laws are different depending upon what jurisdiction you're in. And the reason why we need legal professionals is that the law is foggy and can be argued in many different ways, which you can see might be why, new Supreme Court justice appointments are very fervently protected or argued about. So that's kind of why we have to do this. So before we do legal research, we might want to talk about how we do it. What are the tools we use? So one of the main tools is our legal dictionary, right? We have to figure out what legal terms mean before we start reading them. And we have our Blacks as a text, and we have the Blacks Online for our legal terms. And in a legal dictionary, you look alphabetically for contract, okay, and then it'll tell you the definition. Now, sometimes different words mean the same thing. So you can also have on your desk, or you can do an online legal thesaurus, right? Thesaurus gives you other words that mean the same thing, synonyms for our legal terms. So if we have a contract, it might also, someone might refer to a covenant. You might know what a contract is, but you never heard the word covenant before. You go into the thesaurus and then you realize all they're talking about is a contract. So it's helpful to use these legal know the synonyms and use these tools before you look through an index of a legal book. Okay, so where is my table 1-1? I think I'm already on chapter 2 over here. So let me go to my ebook. Did I open my ebook? Here it is. Okay, so I'm going to go to chapter 1. To my table of contents in chapter 1 of our Hamey's text. This is kind of helpful because I have it in an ebook form. Okay, so here's our legal dictionary. Just some legal terms that, we looked through some of these in our module last week, but that you might want to figure out what they mean. Remember, affirm is one of those dispositions, which is how an appellate court decision affects the lower court decision. Reverse is another one of them. Okay, the difference between a plaintiff and a defendant, difference between criminal cases and civil cases. The appellant is someone who is filing an appeal. The appellee is the person against whom they're filing that appeal. What is an appeal? What is precedent, remand? So those are just some legal terms that maybe you want to play with again on your own time. The online Blacks to find what those terms mean. Oh, here they go. Oh, we go. Civil, criminal, plaintiff, defendant, motion for summary judgment, precedent, remand, respondent, reverse, writ of certiorari. So the writ of certiorari, we'll talk about that a little bit. If you are filing an appeal in a case, you have the right of one appeal to the first appellate court. If you are requesting that an appeal be heard by a higher appellate court, say the U.S. Supreme Court or the Illinois Supreme Court, you have to file. They have to approve your appeal. They're not, if this is something they've decided a bunch of times, they don't think it's important. There's only one Supreme Court, one U.S. Supreme Court and one Illinois Supreme Court, so they have limited time. So if they approve it, they file what's called a writ of certiorari. They also call it cert, C-E-R-T, period. And then they say, yeah, we're going to hear your appeal. So if you know that the cert has been granted, you know that this case is going an extra step. Okay, so when we are doing our legal research, we acquire facts. The facts might be a conversation with a person in our firm or our office to see what has happened. It might be a client interview. From those facts, I have to figure out what legal issues arise. Okay, Joe was walking down the street when it was snowing, slipped on ice, hurt himself. Okay, so it's issues of negligence. Okay, do you have a duty to maintain an ice-free sidewalk? Maybe it's an issue of what damages are allowed under that. So just from that set of facts, you have to figure out what legal issues you're dealing with. Okay, and then after that, you find your law. Okay, so this case, it's a negligence case. Negligence case is state law. Then you start looking in state law cases for slip and fall and icy cases and things like that. And then after you find those cases, you read them and you look at their facts compared to your facts. Okay, was it, the sidewalk of a government building versus the sidewalk of a residential building or a commercial building? Those are things that might make a difference. Was it just full of snow, or had they attempted to shovel the sidewalk already? Okay, and then depending on the cases with the facts closest to yours is the law that's really going to apply for you. And then you communicate your findings. So your findings, they might be verbally, call the partner you're working with or the attorney you're working with. They might ask for a memo. They might ask for you to draft a letter. They might ask for you to start drafting some sort of document to the court as part of your communication of your findings. So that's always your process, no matter what it is. My example or your facts might be different, but the process of getting your issues, finding your law, comparing your law to the facts, and then communicating your findings is the legal research process. All right, so a second ago I said, oh, you might be drafting something, a letter or drafting a document for the court. One of the it's like the primary and almost lone ethically important thing to note for a paralegal is that paralegals cannot give legal advice to people, clients, or otherwise. If they do, they are engaging what's called the unauthorized practice of law. Okay, it's not even malpractice because they're not authorized to practice law, and so it is unauthorized. It's illegal for them to give legal advice. It's not authorized. Okay, so if you are doing a research project for your attorney, say what work product do you want? Do you want a memo? What do you want? And they say, we'll draft a letter to the client. If you are drafting a letter to the client, you cannot give, under your signature, you cannot give legal advice. Now you can draft a letter that then the attorney approves and edits and changes for their signature with legal advice. So you're just giving the first step, and then they have to have supervision. So just be very careful. In every document that you sign, and make sure you sign as whatever your title is, legal assistant, paralegal, law clerk, whatever your authorized title is, so that no one knows that nobody thinks you're pretending to be an attorney and to give legal advice. So Legally Blonde, she was a law student. She wasn't a lawyer. And she ended up trying a case. And you may recall that there was a special rule in, I think it was Massachusetts, that allowed a law student to appear in court so long as she was under the supervision of a licensed attorney, and that one was Luke Wilson. So that's, I just always think of that to make sure you know that not just anybody can appear in court. And posted that little video part of Legally Blonde to the learning module so that you could look at it for fun if you'd like. Okay, and then any legal research that you complete, you have to make sure it's thorough, right? You've researched everything, that it's accurate, that it's right, and that it's current. So that's kind of your ethical responsibility as a legal researcher. Okay, so some things that you might be doing. You are going to you might be doing client interviews or gathering facts. You might have piles and piles of documents that you have to summarize and organize, so you know what the facts are. You can give an accurate description of the facts. You might be conducting legal research, summarizing relevant law, drafting legal memorandum, cite checking, right? You move for case citations and statutory citations, and just that the form is correct, being the attention to detail person to make sure that all of those things are correct. And then you might, if something else might be coming in from another office, and you might be reviewing that and relaying that information to the attorney that you're working with. So those are just some common assignments you might be given as a paralegal. All right, so we're going to skip on to our U.S. legal system. Okay, so our U.S. legal system is what's called a federalist system. We have two forms of two areas of government, I guess I would say. We are subject to federal laws and state laws. So if you are a citizen or a resident of the United States of America, you have to make sure that you comply with both federal and state laws. And if you are a business person or a business in the United States of America, you have to make sure that your business complies with both federal and state laws, and they each make their own laws. So remember, when you're doing research, you may have to search both state and federal laws. Or before you perform your research, you might have to determine, is this an issue that is governed by federal law or by state law? Okay, and when there's different books or different sources that have state law and federal law. And remember, when you're doing state law, it's the state that you're sitting in, the state that you're in. Yeah, okay, I just said that. The Supremacy Clause of the United States Constitution in Article 4 says that the supreme law of the land, this is always a quiz question, the supreme law of the land is the United States Constitution. Every person in the United States is bound by the laws in the Constitution, and laws made by either the state or federal government cannot be in contrary. So Constitution is the Supreme Court of the law, and if there is a conflict between a state law and a federal law, the federal law will prevail. Okay, so different kinds of laws that we have. Constitution. Constitution is the document that establishes the government. Okay, we have our United States Constitution and we have our Illinois Constitution. Illinois Constitution establishes the Illinois state government and the format therein. Okay, then we have statutes. So statutory law, statutes, codes. Remember that there's a T in there. It's not a statue like the Statue of Liberty. It's a statute with a T. Okay, so they call it code. Statutes are made by our elected representatives. Okay, then we have our administrative laws. Administrative laws technically come from the executive branch. So in state, it would be the governor. In federal, it would be the president. And those are rules and regulations made by agencies like the Department of Labor, the Internal Revenue Service or the Illinois Revenue Service or the EPA, all of those kinds of agencies that do day-to-day work in our governments. Okay, and then we have case law, common law. We kind of started talking about that last week. So those are just places we would look. Okay, even if it is a state law issue, and you try to figure out what court you're going to file in. So traditionally, if it's a federal issue, you file in federal court. If it's a state law issue, you file in state court. However, if the two parties are from different states, they call that diversity of citizenship, and the damages are greater than $75,000, you can file in federal court, in the federal court that you reside in if you're the plaintiff. Okay. But the law that's applied here, it's not going to be federal law. It's going to be the state law where the incident occurred. Okay. So again, before you start researching, right, we've acquired our facts, we've done our issue spotting, and then we're like, well, what kind of law am I looking at here? Is it a constitutional issue? Is it something that a code or a statute would apply? Are there agency regulations? So back to the sidewalk, if it's like a commercial one, are there, I don't know, OSHA regs, or are there municipal ordinances we have to deal with? Would there be common law? That would be helpful as well. All right, so common law, which maybe is the most, I don't know, detailed area of law in our legal system, comes about through opinions written by judges. Okay, so there's a dispute between parties. They can't resolve it on their own, and one of them files suit. The suit goes to court, a decision is made, and one of the parties appeals the decision. Okay, the appellate court, which is a panel of judges, makes a decision, and they write a written opinion, and that written opinion becomes law. And that's what we look at. That's what we're reading when we are reading case law. And prior decisions made by these appellate courts set what we call a precedent. Okay, precedent must be followed by future judges. They call that stare decisis, right? We saw this in our definitions from the homework last week. Stare decisis is Latin for it stands decided. Now, we'll talk later on in the semester about what is precedent, what is mandatory authority on a court, but, just for the time being, we talk about that prior decisions can be precedent and binding on future judges. Okay, so we call it common law, we call them case law. The written decisions are opinions or cases, all sorts of synonymous with each other. Okay, we have our different kinds of sources of law. And our legal system, our Constitution has set up a system of checks and balances so that one branch of the government doesn't run amok. There's checks by other parts of our government. Okay, so Congress or our state legislature, they pass laws. Okay, and then the courts can review the laws. They can review the laws if a case has been brought to either interpret what the meaning of the words in the laws are, to determine if the law applies in a particular situation, or to make sure that the law does not exceed the requirements that in the U.S. Constitution or the state constitution, for that matter. So the courts check the lawmakers. Okay, so then the agencies, that's an executive branch. They make rules and regulations. EPA says emissions can be blah, 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 or the IRS does it implements tax codes. Courts can review agency rules and regulations and make sure that they don't exceed the authority granted to them, and what if any rules and regs to make sure they were applied appropriately to the person they were applied to. Case law can be checked by a court system. It may be reversed or overruled by a newer decision. And then lawmakers can make laws that overturn common law or change it. Okay, and then executive orders can be reviewed by courts. You might recall that a lot of people were filing lawsuits to change or overturn Pritzker's COVID orders, saying that they weren't complying with the appropriate rules of executive orders. In New York, they were making laws about religious, um, meeting for church or synagogue or whatever, and the court found that that was Cuomo's rules were exceeded his rights in executive orders and violated the Constitution for under religious freedom rights. So that's kind of just an example of executive checks on executive orders. So those are kind of all of our laws and how they work in relation to each other. One of the things that is an important concept to understand is the rule of law. People talk about the rule of law, some sort of pronouncement of government that establishes some sort of code of conduct. Rule of law, you can just call it a law. So a rule of law is a law. And when we talk about primary sources of law or primary authority, that would be a law. Okay, secondary sources. So the primary sources is the actual law written down, right? You have your cases, you have your statutes, you have your rules and regs, you have your constitutions. And then we have secondary sources that explain the law, analyze the law, summarize the law. So when you're doing legal research, you have to get your answer from a primary law source and give the correct citation. All right, so we have some examples in Statsky, and the Statsky book, which is the navy blue book. I don't have that one in PDF, so I can't show it to you on the screen. But if you look on page 5, you have primary authorities: opinions, statutes, constitutions, administrative regulations, charters, ordinances, rules of court, executive orders. Those are not all primary sources. So administrative decisions are not really treaties. Okay, no, maybe they are. Okay, so treaties. I thought it was saying treatises. Treaties between international parties. But I think administrative decisions are, well, I guess they're primary law, but they don't have precedential value. And then opinions of the Attorney General, which they have there on the bottom of the page. They're advisory, so they're not really primary law as well. The secondary sources on page 27 of Statsky are things like digests, legal encyclopedias, legal dictionaries, legal periodicals, treatises, which is books that explain a certain area of law, law review articles, all sorts of things like that. All right, I'm going to pause for a second and then we'll kind of do this little exercise together.